I am Rich Andriano, a practice leader of the Mortgage Banking Group at Ballard Spahr. Before turning to our webinar, I want to take a few moments to let you know of resources and upcoming webinars. I note that the participants in this webinar today will receive a copy of the slides along with a link to a recording of the webinar. There's no need for you to request that. It will be sent automatically. Now, in this slide, we note 3 helpful resources that you can subscribe to receive. On the left is our award-winning blog, the CFPB Monitor. In the middle are various e-alerts that update recipients on important consumer financial law developments. And finally, on the right, our biweekly mortgage banking update that focuses on matters of interest to the mortgage industry. With both the e-alerts and mortgage banking update, you can indicate your areas of interest, and you can follow instructions and send the email for questions to subscribe to the various items. Now, on our next slide, we have various upcoming webinars that are coming out throughout the rest of the year, some soon and some through November. And as you can see, there are instructions at the bottom of the slide to register for them. And again, you'll be receiving a copy of these slides, so don't have to hurry and write down the information right now. Now let's turn to our presentation. We are many years removed from the beginning of the mortgage crisis, but the National Mortgage Settlement and CFPB servicing rules are both relatively current. Now, the National Mortgage Settlement occurred early in 2012, and then about a year later, in January 2013, the CFPB released the servicing rules. Nevertheless, we have found that many regulators believe that the servicing industry in general should have been working to implement concepts in the settlement and also the servicing rules years ago before they actually existed. In the CFPB servicing rules, while the CFPB followed Dodd-Frank in some respects, it also went beyond Dodd-Frank and included in the rules concepts that clearly were based on the National Mortgage Settlement. Yet the CFPB stayed with the 1-year implementation timeframe provided for in Dodd-Frank, even though it had added requirements not contemplated by Dodd-Frank that included significant staffing and system upgrade requirements. It appears this approach was at least based in part on the Bureau's belief that the servicing industry should have already implemented reforms and been working to further improve servicing functions. Nothing demonstrated this more than early this year when Deputy Director of the CFPB, Steve Antonakis, spoke at the MBA National Servicing Conference. That was in February. He started by noting the rise in mortgage delinquencies in 2006 and then stated, and I quote, "Nearly 8 years have passed, and I remain deeply disappointed by the lack of progress the mortgage industry has made," close quote. So in February 2014, the CFPB referred to an 8-year period to implement changes, yet the National Mortgage Settlement had existed for only about 2 years, and the CFPB servicing rules had existed for only 1 year. Given this background, we thought it would be helpful to revisit the settlement and the servicing rules, and also the Bureau's focus on the need for a compliance management system. We thought it important to address differences between the settlement and the servicing rules, and also address issues experienced by servicers and lessons learned through the settlement. At the end, while a lot of the efforts have been federal, we will note various state efforts to move into the area. Now, joining in the presentation today are my colleagues John Socknet and Michael Waldron, who along with me are practice leaders of the Mortgage Banking Group at Ballard Spahr. The Mortgage Banking Group has over 60 members throughout the firm's offices, helping industry with regulatory, litigation, enforcement, and transactional matters, including both core mortgage banking and related matters such as employment and compensation matters. Also, we're very lucky to have joining us Tony Lendez, a partner in the New York office of BDO Consulting. Tony assists clients with various matters, including securities litigation, professional liability, and corporate internal investigations involving alleged financial statement irregularities and management fraud. Of particular importance for today's presentation, BDO Consulting was appointed by the National Mortgage Settlement Monitor as the primary firm to assist the monitor in the oversight of servicers under the settlement. And Tony is the lead BDO partner who oversees this engagement. So Tony has excellent insight and experience he can share with us. And with that, I turn the presentation over to Tony.
Thanks, Rich. Good afternoon, everyone. I plan to provide some information on the issues that have been identified as part of the National Mortgage Settlement involving the various governmental entities and the 5 largest mortgage servicers. First, I'm going to provide a little bit of background information on the National Mortgage Settlement, also known as the NMS. And then later, I'll briefly discuss the relevance of the NMS on the CFPB rules, and then some of the challenges that have been faced by the 5 servicers in complying with certain of the servicing standards. And in particular, I'm going to cover the loan modification request and process, as well as force-placed insurance. Now, just some background on how the NMS evolved over time. On or about 2010, the Attorney Generals began to investigate a variety of allegations involving robo-signed affidavits in foreclosures, and also a series of issues with respect to loan modification applications. There's a lot of complaints from consumers coming in regarding lost paperwork, long delays in processing applications, and even missing deadlines. And so fast forward to 2012, the Justice Department, along with HUD and 49 states, including D.C., and the nation's then 5 largest banks, mortgage services, entered into consent judgments to address some of these issues that had been raised by the AGs. That covered approximately 60% of the market, and over time, it's evolved to include now what is 7 banks, services that are involved in a national mortgage settlement. As you may recall, about a week ago or so, SunTrust became another participant bank in a national mortgage settlement. Now, the settlement had 2 primary requirements. One, it required that the services comply with certain servicing standards. There were 304 servicing standards, and the way that that was being evaluated, whether or not they were complying, is the consent judgments included certain metrics that were designed by the crafters of the consent judgments that enabled the servicers to evaluate whether or not they were complying with certain of the servicing standards. The other major requirement of the consent judgments included consumer relief to distressed homeowners. And in that regard, the consent judgment spelled out that the services were required to provide about $20 billion in creditable relief. At the end of the day, they provided over $50 billion of relief to 600,000 families. The reason why there was a difference between the creditable relief and the actual ultimate relief that was provided is because some of the relief that was provided wasn't eligible for dollar-for-dollar crediting. For example, first lien mods that were serviced for others only received 40 cents to the dollar of crediting for all modifications. And just by way of background, Joseph A. Smith, was appointed monitor of the National Mortgage Settlement, and he is a former banking commissioner of North Carolina. In connection with that process, he established what was called the Office of Mortgage Settlement Oversight.
Yeah, Tony, this is John. Just real quick, if I could get a little more color on Joe Smith. As Tony said, he was the North Carolina banking commissioner, and he held that role for about 10 years until he resigned in February of 2012. And initially, he was the Obama administration's choice to replace Ed DeMarco as director of the Federal Housing Finance Agency. But Joe ultimately withdrew his name from consideration when it became clear that the Republicans were going to oppose his appointment, and that would prevent them from getting a full Senate vote. But what was interesting is his opposition was based on his based on concerns that he would object to efforts to persuade FHFA to allow Fannie and Freddie to absorb greater losses through principal write-downs or other foreclosure mitigation programs. So again, he ultimately withdrew his candidacy, and as we know, Mel Watt more recently was finally confirmed in that position. And for those of you who are familiar with Smith and particularly North Carolina, during his tenure as commissioner, he was viewed as someone who understood the industry. He had spent a number of years in private practice doing securities and banking law, among other things, and he was even a general counsel for a bank holding company. And the other issue I wanted to point out is that North Carolina, in particular, Joe Smith, had a very pro-consumer reputation, and he was known for being particularly difficult on licensees and institutions that North Carolina regulates. When the regulators discovered significant issues, and when the regulated entities didn't actually take steps to address those issues. So, and a quick quote from him, banks should have the opportunity to make it right, and this is in the context of the servicing issues, and if they can't or won't cure, they need to consider enforcement actions and penalties, with egregious violations warranting big penalties, and that failing to comply will result in state AG actions and injunctive relief from the courts. So I think it's important to sort of keep that in mind as we discuss the NMS in more detail, the ongoing monitoring, and then the interplay with the CFPB rules.
Thank you, John. And on the slide, you'll see that there's a link, a hyperlink to the website of OMSEL, and there you'll get more information on the monitor and on the various reports that he has issued since inception of the National Mortgage Settlement. Now, as Rich mentioned early, we were appointed as the primary professional firm, and the way that Joe designed the project is he then appointed 5 other accounting firms to the 5 services that initially came into the settlement. And so we have been responsible for coordinating the work of the other accounting firms under the purview of Joe Smith and his team at OMSEL. And I have been the lead partner from BDO, managing the project both from the perspective of the servicing standards as well as from the consumer relief that's been provided. And all of the consumer relief has already been provided, with the exception of the 2 new recent banks that came into, actually one non-bank, Aquin and SunTrust, came into the settlement recently, and they now have consumer relief obligations that we will oversee. Now, Michael Waldron is going to provide a little bit more information on background on the CFPB rules.
Great, thanks, Tony. When the National Mortgage Settlement was announced in February, it was actually February 9th of 2012, Illinois Attorney General Lisa Madigan set forth a press conference, and in that press conference, she indicated as follows: "Know that this is neither the beginning nor the end of our work to hold banks and other institutions accountable for the destruction they've caused our families, communities, and country. Today's settlement should serve as a warning for financial institutions. There are consequences for engaging in practices that jeopardize the stability of our communities and our economy." That statement rings very true in that there were further efforts, and the most formalized of them are the CFPB servicing rules, which became effective, as everyone knows, in January of this year. 1,179 pages covering 9 major areas, as you all know. The reality with the servicing rules, similar to the National Mortgage Settlement for those involved, is that it's incredibly resource intensive to analyze, implement, operationalize, and comply with. We are now in the stage of ongoing analysis, certainly ongoing implementation, and an ongoing effort to operationalize and comply with these rules. Where we're seeing the greatest focus in terms of the inquiries that we are getting are the areas that are listed in this slide. I think it's important to note that one of the ways that folks can help create efficiencies, both internally and certainly through their use of outside resources like law firms like Ballard, is really to track the clarifications that are sought and provided. At Ballard, we have an ongoing living, breathing document. It's a 110-page document which essentially tracks all of the questions and our responses to clients that are associated with the servicing rule. And that allows us to create efficiencies internally and for our clients. So that if a question is asked, the first place that we go is to see if it's not only already been asked but answered. That allows us to get back to clients more quickly and give them the efficiencies that they deserve. On the periodic statement side, I'll just talk a few minutes about some trends, and then I want to move on to compliance management systems. The questions there really focus around borrowers in and emerging from bankruptcy. We're fortunate at Ballard to have a bankruptcy practice, so we're able to draw upon our attorneys there for their insights, both with regard to how to treat borrowers emerging out of, how to fashion statements on the periodic statement, so that we put our clients in the best position possible with not only the regulator but with the bankruptcy court. The error resolution and information requests, I think this is an area that for most has been the most time-intensive and resource-intensive aspect of the new rule. A framework needs to be developed, a tracking system. Obviously, there's tight turn times, but there are new obligations with regard to what you have to produce. So, for example, the obligation to produce, if requested, documents relied upon in making a decision is one that a lot of folks have questions around and are needing to devote resources to. Continuity of contact, and Tony will go into some of the differences with Spahr and continuity of contact, but we get questions around the appropriate size of the teams and what other industry members are doing, that's an area of focus certainly, especially for what I'll call the smaller to mid-sized players. And then obviously loss mitigation. Another area on periodic statements that I should have mentioned was charged off loans. Oftentimes we get questions about whether or not there's an obligation to provide ongoing periodic statements once a loan is quote-unquote charged off. Most shops use that term and it's utilized because it's an internal accounting treatment. The lien is not released. If the lien is not released, our view is that the periodic statement must continue to be sent. Just because it's charged off internally for accounting purposes does not eliminate the obligation to send the periodic statement. So there's been a lot around that as well. Rich, let's turn to the next slide. So the compliance management system, and you know, some may say, well, how does this fit into the National Mortgage Settlement and what everyone's trying to accomplish with the new rules? The reality is that the lens that you view the CFPB servicing rules through should be shaped by not only the National Mortgage Settlement, which Tony's going to get into the specifics there, but also the obligations that your institution has around compliance management systems. Many of the issues that folks are experiencing with regard to implementation are really issues around compliance management system obligations and whether or not there's an appropriate foundation there. And many of the issues that have been experienced by servicers in the National Mortgage Settlement, again, that Tony's going to cover here shortly, are issues that the CMS is actually meant to cover, and that's not coincidental. The lessons learned from the National Mortgage Settlement and from the OCC consent order not only shaped the new servicing rules, but it shaped the obligations with regard to compliance management systems, training, staffing, reporting, quality control, vendor oversight. So what is a CMS? I think by now you all should have a sense that it is what establishes a company's compliance responsibilities. We used to call it the culture of compliance. It communicates those responsibilities to employees. It ensures that the responsibilities for meeting the legal requirements and internal policies are incorporated into business processes. It allows for reviews of operations to ensure responsibilities are being carried out, and that corrective action and updates to both systems, tools, materials, training, et cetera, are being done as necessary. On the next slide, you'll see really what we call the 4 cornerstones. It's the 4 control components of an effective CMS. It's board and management oversight. It's having a compliance program, which is policies and procedures, training, monitoring, and corrective action. It's the ability to respond to consumer complaints. That's obviously a big aspect of the new rule with regard to information requests and the concept that I indicated earlier of error resolution. And then there's compliance audit. The next slide is really more of a visual takeaway for you all. No need to get into the specifics here, but this just lays out the 4 components and provides additional detail with regard to each. And again, what I would do is urge you, as you're listening to Tony, who I'm now going to hand it over to, take his comments in stride. Take them in stride with regard to how your compliance management system is built or how it needs to be refined. Because those, again, are not only the lessons, but the lens that we should be viewing all of this through. Tony?
Sure. Thank you, Michael. As Michael pointed out, the CFPB regulations became effective January 10, 2014, and the National Mortgage Settlement runs through April 2016. So what essentially has happened is in the middle of our test work, we've actually had to deal with a situation where the servicers need to now comply with the CFPB rules. And so we embarked on an analysis to compare, at least as it relates to the metrics that were being tested. We didn't compare all the servicing standards, but we did compare those servicing standards that were tied into the metrics that were being tested. And we essentially noted that they're about the same. There are a couple of differences here and there. And for example, I'll point out with respect to loss mitigation activities under the NMS, it's essentially a 2-step process. There are metrics that test first whether or not the home retention options have been complied with, the servicing standards relating to that, and then whether or not if they're not eligible for home retention and they go on to let's say short sales, there are servicing standards related to that, and there are metrics that are associated with that to test to ensure that the servicers are complying with the servicing standards. The reason this is important is because when I get into some of these findings, I think they're relevant, even though the NMS isn't exactly the same as the CFPB rules. They're very similar, and I think that understanding some of the issues that the Big Five encountered may be helpful to some of the folks on the phone now. Under the CFPB rules for loss mitigation, they view it as kind of a 1-step process, where servicers are required to evaluate all borrowers for all loss mitigation options at the same time, not just for loan modifications, but also for non-home retention options. And even though that is the case, the CFPB does recognize that this process is still essentially a 2-step process. It's not contemplating that a complete loss mitigation application would also include all documents that would be necessary for, say, non-home retention, such as a short sale. And from a practical perspective, the way we're looking at it is that under CFPB rules, a complete loss mitigation application is essentially the same as a complete loan modification application under NMS. Now, let me get into some of the issues we've been seeing during metrics testing. On the next slide, we talk about loan modification packages and missing documents. Under the NMS, the internal review groups, and I'm sorry I didn't cover this, internal review groups are independent internal audit type groups that were required under the consent judgments. Each of the services had to adopt an internal review group. Some of them range from sizes of 20 to 30 to 40 people. And the internal review group is testing the metrics every quarter. and then the secondary firms are coming in and reviewing their work, and then we oversee the work of the secondary firms. So under NMS, the loan modification packages with respect to missing documents, the services are required to send a letter to the borrower within 5 days of receiving a loan modification package, notifying the borrower of any missing information for the package to be considered complete. And then they have to give the borrower 30 days from the date of the notification to submit the additional information prior to determining whether or not to grant the loan modification. And under the CFPB rules, you have a similar 5-day requirement, but the CFPB rules essentially apply to applications received more than 45 days prior to the scheduled foreclosure sale. The CFPB rules also don't specify that you have to give the borrower 30 days to submit the additional information. What it does, the CFPB rules indicate in the 5-day letter that the borrower should be given a reasonable date by which to submit their missing information. And what the CFPB rules do is they provide guidance on selecting that reasonable date. And for example, few examples they provide in the rules is to provide the missing information by the date when submitted docs that have may become stale, or perhaps submit the missing information by the 120th day of delinquency. Now on the next slide, I cover some of the issues that we've been seeing with respect to missing docs. What we found in our review of the metrics testing is that some of the services failed because the time frame to mail the letters to the borrowers is just too long. There were too many steps in the process, so the services embarked on a process of evaluating the various steps and becoming a little bit more efficient, and in some instances they either eliminated certain steps that were maybe redundant, or they consolidated certain steps. The other issue that we saw was that there was limited quality control processes in place, and there's also limited training. And so what these services ended up doing is, in order to correct that situation, they expanded their QC teams and also provided agents with additional training. Another issue that we saw was the staffing was just way too small. They didn't anticipate all the various procedures that had to be applied, and so the services increased their staffing in certain areas. Also, another issue that was encountered is the review time to review the modification packages was just way too short. They were working maybe 8 hours, 12 hours a day, 16-hour shifts, and what they ended up doing is they had to expand that to 24 hours in order to be able to comply with the metric and the related servicing standards. And then finally, we also saw there were situations where there weren't any backup teams. And so what some of the services did is they initiated a process for backup teams, and they generated reports where after 3 days of receiving a loan package, if there wasn't a response sent to the borrower, or there wasn't anything in the works, that then they would undertake to evaluate some of the missing documents and send out the 5-day letter themselves. So the backup teams actually came into play when the original teams that were responsible for doing this weren't able to catch up to the volume that was coming in the door. On the next slide, I talk about, again, it's loan modification, and this issue dealt with the responsiveness to the request itself. And under the NMS, the internal review groups are testing to determine whether the services respond to a loan modification request within 30 days of receipt of all necessary information. And this basically means now they've got a complete package in the door, a 5-day letter has gone out, the borrowers have responded, they provided the missing information, now they have a complete package. And the other test that the IRGs were doing is they were then evaluating whether, once the modification decision was made, if it was a decision where the borrower was declined the modification, they were verifying that services were sending out the notification letters of declinement within 10 days of the decision being made. Now, under the CFPB rules, we kind of have a similar situation. We do have a 30-day requirement, but the issue there is that the notification of both the denial or acceptance must occur within 90 days, within 30 days. And there's really no additional 10 days to notify the borrower if the modification request is denied. Now, on the next slide, I show a few of the issues that we saw, and some of these are kind of similar to what we saw with respect to the missing docs. Limited reports to track the status of the loan modification request. We found that some of the services didn't have the appropriate reports, and so what they did is they created new reports in order to help them track the status of loan modification requests. And again, you know, the staffing was an issue, it was a challenge, and so they underestimated the number of people that they needed in order to address these servicing standards, and so they increased the staffing in certain areas. And again, we had a situation where there was limited quality controls in place, and so some of the services expanded the QC teams to ensure that the loan modification requests were being responded to in a timely fashion.
Tony, it's Michael. Quick question with regard to the expansion of the QC teams, and a question we often get that's not a legal issue, but one that our clients want practical advice on. Are you finding in your efforts related to the NMS or otherwise, the expansion of the QC teams, are those QC teams focused only on the servicing efforts, or are they from the QC department as a whole? So some of those QC teams also do origination-related activities as well, or are they segmented?
No, they're pretty much in the servicing area because that was where the challenges were, and so they essentially bolstered up the teams in those areas under the servicing standards in order to ensure that they would comply with the servicing standards.
And those folks only focus on servicing issues. They don't also, in quote-unquote off-time QC on origination-related issues?
It's conceivable that they do that. It's really hard to tell because some of these QC teams are large, and you know, assuming that you want to, you know, get the most out of your employees, if they have downtime, I would suspect they might be asked to do other things. But the intent of these QC teams were to address the specific issues that were being raised when we were doing the metrics testing.
Got it. Thanks.
Sure. On the next slide, another area that was an interesting situation, and the reason why this was kind of interesting is because, you know, force-placed insurance is really often handled by third-party vendors. And so this was an area where, to some extent, the services had control but didn't have that much control. But under the NMS, the IRGs were testing to determine whether the servicers terminated force-placed insurance within 15 days of receipt of evidence of existing insurance, and that they also refunded a prorated portion of the borrower's escrow amount held for the insurance. And under the CFPB, both number 1 and number 2 are essentially the same as the NMS. And some of the issues that we saw related to the frequency of communications with the third-party vendor. What happened was, I guess some of the services underestimated the amount of dialogue that had to go back and forth in order to ensure that they could comply with the servicing standards with respect to force-placed insurance. And so what some of the services had to do is they had to step up the frequency of communication with the third-party vendor. And that's, you know, probably not unusual because, you know, the third-party vendor is oftentimes not really, it's part of the system of control, but it's not embedded within the organization, so it's dealing with a third party that could be a challenge sometimes. The other issue that was encountered is that sometimes the employees of the third-party vendor weren't appropriately trained, and so the services ensured that the training of those individuals that were handling their force-placed insurance received the appropriate training. One of the other issues that we saw was that some of the reports that were being produced by the third-party vendor didn't provide sufficient information to track whether or not folks were submitting the evidence of insurance and refunds were being provided. And so a series of additional reports in some instances were created in order to ensure that the vendor could track the status of the borrowers with force-placed insurance and this periodic follow-up. And then finally, The issue that was kind of interesting is, there was actually situations where the borrowers had provided evidence of insurance, and yet for some reason that information wasn't communicated to the services, and so the services embarked on an effort where they essentially communicated more often with the borrowers to verify whether or not they had insurance in place and had provided the required evidence.
Tony, this is an area at first place, I think, where what I'll call the rest of the industry, those that weren't counterparties to the National Mortgage Settlement, really did take the lessons learned out of NMS and applied them as best practices, because it's an area where we really aren't seeing much heartburn from our client base with regard to implementing the CFPB rules around force-placed insurance.
That makes sense. And on the next slide, I have just a couple of other things. I thought it would be helpful to cover some of the new metrics that Joe added as a consequence of meetings that he had nationally with housing councils and other folks, housing advocates, and also some of the issues that we saw in our analyses of consumer complaints, because one of the provisions of the consent judgments is that the services are required to send Joe Smith the executive office complaints, and we set up a system where we analyzed the complaints that were coming in, and we put them into compartments in terms of servicing standards and metrics. And so we were able to see which of the servicing standards were receiving a large volume of complaints. And so that helped in the process of developing new metrics. And some of the areas where we did see a fairly large volume of complaints, or where Joe was receiving a lot of complaints from housing advocates, is in the area of the SPOC. What we found is that sometimes people were complaining about the fact that they had a SPOC that was assigned to them. The SPOC left, and they were never, informed about a new SPOC that was assigned. And so there's now a new metric that Joe added that deals with the reassignment of a SPOC when the existing one is no longer with the organization. And more importantly, that particular metric that was added also includes procedures that are designed to evaluate and remediate any SPOC performance issues, because that was another area where people were complaining about situations where the SPOC wasn't fully informed about some of the issues that they were running into. And in particular, bankruptcy was one area that was pretty significant. The other new metric that was added as a consequence of some of these complaints and issues identified by Joe is the new metric that is designed to evaluate the accuracy of monthly billing statements.
Hey, Tony, before you go on to that, quick question around SPOC. Based on your involvement and experience, how do you feel SPOC is working versus, how you view the team approach of continuity of contact?
Well, I think that, it's a learning process, in my view. We have seen a lot of complaints now. We all know that people complain, and sometimes complaints aren't valid, and all you're doing is you're really getting information that's negative information. Nobody's ever going to complain about how good a SPOC is doing their job, but nevertheless, we did initially receive a fair number of complaints in the SPOC area, and but that, we're seeing that is getting better. It's not only being addressed by the services, but it's also the volume of complaints is coming down a little bit. But as far as whether it's an individual SPOC or whether it's the team approach, we have seen some of the servicers adopt the team approach, and we have found that to be acceptable, and that seems to be improving things a little bit. So that helps, because instead of all the burden on being on one individual, having all the knowledge that's necessary to respond to borrower questions, the SPOC teams can collaborate and discuss, issues amongst themselves, and they learn from themselves. So in a way, I think it has improved the process. Good, thanks. Sure. some of the other new metrics that have been adopted deal with, again, the missing documents issue. That's been a big deal, and so we adopted a new metric to deal with missing documents, to essentially kind of revisit the concept of missing documents and see, to make sure that, you know, if in fact something is missing, it really is. Some of the other issues that we saw that we addressed with some of the new metrics is some instances, modifications were being denied prematurely without fully considering the information that was available. So now there's a new metric dealing with that. There's also situations where foreclosure proceedings might not have been delayed appropriately to provide for time, the appropriate time for distressed borrowers to receive the relief that they were required. So there's a new metric that deals with that. And then finally, a new metric dealing with the communication of denials. And in particular, the new metric now is designed to provide the borrower with a reason for the denial, as well as the factual information that was considered in making that determination. And it essentially provides now a 30-day time period. This is what we're testing. These were one of the servicing standards, but we weren't testing them. Now we're testing them under a new metric. And also, this new metric is designed to provide the borrowers with additional options that might be available to them in terms of loss mitigation activities. I think, John, if there aren't any other questions, I think John Slocknet is now going to discuss some of the efforts by the states to oversee the mortgage services.
Thanks, Tony. Yeah, and I think, as Rich mentioned at the outset, there is functionality here for you all to submit questions, and so to the extent you have any, please do take advantage of having, you know, direct access to Tony, and he's obviously very close to this entire process. And I found that last slide, Tony, particularly helpful and informative. So one of the things, obviously, that we can't forget about is what I call the state overlay, and particularly when it comes to and when we focus on enforcement. It's something that we all are focused on. It's something that we all worry about. And, you know, apart from sort of direct enforcement actions that we're going to continue to see stemming directly from the National Mortgage Settlement and the CFPB rules, we also are starting to see, and think we're going to continue to see, both direct and indirect actions on the part of state mortgage banking regulators stemming from the National Mortgage Settlement. And so, you know, sort of the genesis of these types of regulatory actions are, you know, I guess in some respects potentially unlimited, but there are a handful of likely sources or bases that I'll touch on. The obvious of these is going to be the adoption by states of any of the standards or the standards that are flowing out of the settlement as best practices. Tony just touched on some additional metrics that have been created in response to some concerns. So clearly, other regulators are going to see where are the issues, where are the sticking points for these banks, and where are they struggling. And you can expect that the regulators are going to then use that information and perhaps probe others as they're doing examinations. You know, the issue is around best practices is whether it sort of becomes the de facto standard against which state regulators are going to examine or audit servicers. You know, we know that in some instances best practices will, or in some respects already have, made their way into revised regulations, but also through the issuance of bulletins, policy statements, or other formal or informal guidance that regulators, particularly the state regulators, may be issuing. In other instances, though, I think that the states are going to simply examine or audit to these requirements on the basis of an existing statutory regulatory standard, and arguably in some instances without any potential express authority. So one example of a standard, an existing standard, could be pursuant to a general or specific duty or obligation owed to the consumer. So New York, for example, has a catch-all duty of good faith and fair dealing that's built into its servicing regulations, and New York has used that in the past as justification for requiring servicers to take certain actions. An example was the department's directive to servicers that had used a particular foreclosure firm to refrain from charging borrowers any penalties, late fees, costs, or having interest continue to accrue as a result of any delays related to transitioning away from this foreclosure counsel to new foreclosure counsel. And I think we're starting to see, state regulators use these overarching duties or obligations to incorporate elements of the national settlement into requirements that they're imposing on licensed mortgage servicers to the extent that they're not already part of statutes or regulations. Moving on to the next slide, it's important to keep in mind that some number of the elements of the national settlement are actually already part of existing laws. And I'm sorry, go back, Rich, I'm sorry. Although obviously there's not uniformity across the states. So, if you're a state licensed mortgage servicer and you're operating in a number of states, you already at least have, in some states, had to deal with a number of the obligations that are similar to those that appear under the national settlement. But it's also important to keep in mind that state laws can and do differ, and in a number of instances can be even more onerous than requirements under the national mortgage settlement or even under the CFPB servicing rules. We're starting to see those and starting to get questions from certain of our clients as they're working to implement the rules and then, struggling with additional obligations that arguably are inconsistent under state law. So we've listed, a handful of some of the laws that exist in state laws now, and some of these, again, could have and do have differences from either the CFPB rules in particular. And obviously, failing to comply with these sorts of obligations are certainly going to subject servicers to enforcement actions. Moving on to the next slide, I just want to quickly touch on the Multi-State Mortgage Committee. And this is obviously another source for state regulatory action. As many of you may know, the multi-state exams target, as a general rule, the larger and the largest lenders and servicers. And the multi-state exam manual itself already has, and even as late as a couple of years ago, right after the settlement, already had a section that deals with servicing issues and focuses on a number of the same issues that the national mortgage settlement does: loss mitigation efforts and obligations, the imposition of fees, forced place insurance, record retention. Again, the themes that we see over and over again. You all may recall that the multi-state committee provided support to the AGs actually in connection with their examination of servicers. They have a history of doing and undertaking servicing-related exams. We're going to continue to see the multi-state committee, I think, focus on those issues. They're announced in 2014 that the CFPB and the multi-state committee were working jointly on 9 exams, 6 of them in the mortgage space, and I would expect that at least 2 of those would be focused on mortgage servicers. And the other issue, just a comment about the multi-state exam, and one of the issues that we've noted as we've helped our clients navigate and respond to the multi-state exam reports is that you oftentimes end up having multiple states auditing or examining to a single standard, even if that standard isn't what their own state law is. In other words, examining or auditing to the strictest standard among the various states that are participating in the examination. And that obviously raises concerns about what that means in terms of penalties and enforcement if a particular state is attempting to hold a licensee to a standard that doesn't actually exist in its own law, but at least expressly exists, but then having the regulators point to something along the lines of what New York can do, which is this overall duty of good faith and fair dealing. So again, we just wanted to touch on, don't forget about the states and what is flowing from the National Mortgage Settlement and the CFPB rules are obviously important, but the states can continue to play the role that they have always played and continue to fight for their relevance and focus on, we think, going forward, servicing issues more and more. And with that, Rich, turn it back to you.
Sure, thanks. And we do have some questions. A couple of them are related. The first, relating back to the conversation just a little while ago on responsiveness to loan mod requests and such, and the issues experienced by servicers, that there was a limited quality control process, and that servicers, in fact, then expanded their quality control teams. And a question is, in this, and I know obviously this could vary by servicer and the nature of their portfolio and such, but is there any ratio with regard to the number of QC persons you have and the number of loans serviced that the servicers are falling in, or is there a variance there, or in fact is Joe looking for any particular ratio that he thinks puts you in a good area there in terms of how many QC people you have for loans serviced?
Yeah, that's a very good question, and I hate to answer it with it varies, but it does vary because it really depends on the QC process. In some instances, the QC reviewers will just look at a representative number, and some of the servicers are overachievers and they look at everything. So it really will depend on that, and it also depends on how clear the communication is initially with the borrowers, and how much of the information you receive up front and how little is missing. Sometimes sometimes the communication is very clear, and so there's not really a lot of issues, and so they're not really QCing as much, and they're looking at maybe representative samples of the documents as opposed to looking at every application that's being processed.
Great. And as I know, there was a related question that we had received, and this really, I think the first context is in the context of the National Mortgage Settlement and the single point of contact. And again, I understand there's probably variability here, but question that we get is there any, again, basic ratio or rule of thumb or range as to how many single points of contact you need, or how many loans really is a good number of loans that should be assigned to each, SPOC in terms of that? And any thoughts you had on there, or what the servicers are experiencing with regard to that issue?
Yeah, well, I would say, as far as the ratio or number, it's really difficult to say, but, there are certain requirements, like some of the SPOCs that need to be knowledgeable about bankruptcy issues, for example. They probably would have a lesser workload, because some of the bankruptcy issues are a little challenging, and you really you have to have knowledge of bankruptcy laws in various states and things like that, and you have to deal with the various trustees and so forth. So I would suspect that a SPOC that's handling bankruptcy would probably have a lighter workload than someone who is handling routine loan mods, or for example, those that are handling, they might be handling specializing in like short sales or something like that, and as part of the team approach, on the team, they're going to have some people that will have a lot more volume of, just loan apps, and then some of them will have a lot less volume of, let's say, short sales, but, some might be more complex than others. It's really hard to say. It's going to vary by the complexity of the particular issue that they're dealing with respect to the borrowers.
Okay. And a similar one, and this is more, I think, Michael, you might have some thoughts on this. Again, this is kind of now moving out of the NMS and into the CFPB servicing rule, which instead of using the SPOC concept uses the continuity of contact or the team approach, and a similar issue there. And here, obviously, we're dealing with a much greater population of servicers from small to medium to large who could have varying levels of delinquencies in their portfolios and varying levels of bankruptcies. And I know there's been some inquiries there as to what may be good numbers for any team, the size of the team versus the size of the portfolio. Did you have any thoughts on that?
Yeah, I mean, so we've had a lot of conversations with clients around appropriate team sizes and then the number of loans or borrowers that those teams should focus on. And I do think it depends on the stage of the process of the borrower. But we're seeing team sizes in the 8 to 10 range, and we're seeing numbers commensurate with those teams. Varying on the complexity and, again, what stage they're in. But I think that most people are comfortable having folks on, what I'll call relatively high-touch loans, somewhere in the area of, 70 to 80 loan files on what I'll call the high-touch. And then, obviously, when you have teams, you're going to do a multiplier on that by the number of individuals on the team. But it does vary. We are getting a lot of inquiry around that, and I think it's an area that's still taking shape. And what we advise our clients on is, they know the culture and the efficiency internally, and what they don't want to do is be an outlier on this. There is something to be said about, kind of taking cover within what others in the industry are doing as it relates to grayer areas like this.
Great, thanks. With that now, we're now coming up at the top of the hour. I wanted to thank everyone for joining us and thank all our panelists, particularly Tony. Thank you very much for offering your insights on here. I think it was very beneficial for the audience. Again, for all participants, a copy of the slides and a link to this recording will be sent to you. And we're also working with BDO to prepare an additional webinar in the future, more combining the talents of both Ballard, Spahr, and BDO Consulting to provide topics of interest to the mortgage industry, and look for that in the near future on an announcement of what it will be and when that will be. With that, thank again for everyone participating, and I wish you all a good day.